Hello everyone, my name is Kumar Rahul. I am working as Assistant Legal at Defense Counsel at District Legal Services Authority, Deoghar. I am here to explain you some of the principles of Transfer of Property Act 1882. Here I will be explaining section 1 to section 11 and rest of the section will be explained in other videos. So moving on to the introduction part, we have to read the preamble of this act. The preamble of the act states that it's an act to amend the law relating to the transfer of property by act of parties. Here there is two things. First, the word amend, and the second is the para by act of parties. The word amend, it clearly suggests that the law relating to transfer of property is not exhaustive. It's and it is only to amend some of the law relating to transfer of property and not all the laws. Also, here the phrase by act of party, it suggests that the transfer can only be governed by non-testamentary documents, and that is the transfer can be done only between the living persons. We also call this transfer inter vivos transfer. Uh, if we go to the other sections of this act, we will find that some of the sections are incomplete without the Contract Act or the Transfer of or the Registration Act 1908. So, because of this phenomenon also, this act is not exhaustive at all because it is completed through other acts also. Now we will move on to the next slide, that is commencement and extent. So it's the first paragraph. It suggests that it shall come into force on the first day of July 1882. Of course. Uh, second, uh, second, in the first, it extends in the first instance to the whole of India. It has been extended to the whole of India, but except three states: the Bombay, Punjab, and Delhi, which but this act was also extended to Bombay and Delhi. But in Punjab, it has been extended to only certain extent, not uh, all the laws of this act. Why? Because this act gives the power to the state government to extend this act by a notification through official gazette to its territory wherever it wants. We can read the third paragraph, which it suggests that it can be extended to the state government only. Although it's a national legislation, but it can be extended through the state government only. If we read this says that, but this act or any part of therefore may by notification in the official gazette may be extended to the whole or any part of the state territory by the state government concerned. Now we come to the fourth paragraph of this commencement. It suggests that and any state government may from time to time by notification in the official gazette exempt either retrospectively or prospectively any part of the territories administered by such state government from all or any of the following provisions, namely section 54, paragraph 2 and 3, 59, 107 and 123. This paragraph suggests that the state government has little flexibility with regards to TPA. It can either extend it retrospectively or prospectively. It can extend it to a part of territory or to the whole of the territory. Also, it can extend the TPA as whole, or it can extend the TPA as paragraph as a part in parts. If we look at this line here, it suggests that it can exempt any part of the territory from administered by such a state government from section 54 para 2 and 3, 59, 107 and 123. So it gives, this paragraph basically gives a little flexibility to the state government. Now moving on to the fifth paragraph, we will see that it is said that notwithstanding anything in the foregoing part of this section, section 54 para 2 and 3, 59, 107 and 123 shall not be extended or to be extended to any district or tract of a country for a time being excluded from the operation of the Indian registration 1908. So here the word notwithstanding has been used. It clearly says that the act, this paragraph has an overriding effect on the Transfer of Property Act, which suggests that if if any part of the state of the country has been exempted from the operation of Indian Registration Act, then these sections, namely section 54, paragraph 2 and 3, section 59, section 107, and section 123, shall also not be extended to that particular part of the country or to particular district of the country, whichever uh, which in whichever in whichever this paragraph has not been in whichever the part the Indian Registration Act has not been extended. Moving on to the next slide, we have section 2, repeal of acts, saving of certain enactments, incidents, rights and liabilities, etc. This act basically saves some certain enactments, incidents and rights liabilities which have been there before the commencement of this act, and we will go on to read the provisions of this section. Clause, here it suggests it starts from nothing herein contained in this act shall be deemed to affect. So the word here nothing has been used. So this is the negatively worded provision. So it suggests that this act will not affect. Uh, Clause 2 suggests that any term or incident of any contract or constitution of property which are consistent with the provisions of this act and are allowed by the law for the time being in force. Means this act will not affect certain things which are inherently there or which are in consonance with this act also. So inherently there means that the thing, that the right or the incident or the liability which are there before the commencement of TPA also, and it will be there if there was not there was if TPA was not there also. So we will see here that that incident, the term or incident, or the whatever the rights or liabilities that existed before this act will continue to exist. Example of these are the right to easement of any property. If there is a right to easement of any property before the commencement of this act, it will continue even after the commencement of this act. So from this we can conclude also that the act has no retrospective uh, no not this act is not retrospectively valid. It is an act which is prospectively valid from the date of its commencement. Moving on to the next slide, we have clause D of section 2, which suggests that save provided by section 57 and chapter 4 of this act, any transfer by operation of law or by any execution of a decree or order of a court of a competent jurisdiction. So it also suggests that this act will not affect the transfer by operation of any law, by decree or order of a court, or in execution of any decree or order of the court. So basically, this act, if we have already read the preamble, which suggests that it is done, the transfer to be done by the act of the parties. Here in the order of the court, it is not the act of the parties, it is the order of a court. So this provision saves that order or decree of the court from transfer of property act. Again, nothing in the second chapter of this act shall be deemed to affect any rule of Mohammedan law. Also, again here nothing, if the word nothing has been used, this means the Mohammedan law has an overriding effect on the second chapter of this act, and therefore the TPA is not applicable on the Mohammedan law. Moving on to the next. Moving on to the next slide, we have interpretation clause, which gives us the definition of some of the words of which we will use during the reading of this act. First of all is immovable property, which says that it doesn't include standing timber, growing crops or grass. It is a negatively worded provision which exclusively excludes standing timber, growing crops or grass. This definition is not exhaustive at all. Uh, Here if we look at these three things which has been written in this provision, we will find that these three things, when standing, they are of no use. Once they are cut, they become usable. So in this case, they have been classified on the usage. Uh, so when they are cut, they become movable property, and hence they have been excluded from the definition of immovable property. And this has been said, and this has been held in the case of Bajnath versus Ramdar and others. The Honorable Allahabad High Court held that the legislature has expressly accepted from the definition standing timber trees, growing crops, and grass. The reason why they have been accepted from the definition is that though they are standing for a long time, they are meant not to remain standing, that they can be brought to use only after they have been cut, and that they are meant to be cut sooner or later. So again, the same thing, that is the definition exclude these three things on the basis of usage. Although this definition is not exhaustive at all. Further, moving on to the second word, that is instrument, means non-testamental instruments. If we have read the first preamble of this, it says that by the act of the parties. By act of the party itself means the party is alive. Hence, this the transfer should be done through a non-testamental instruments, and not from any testamentary instruments. Here and hence, in this act, if there is a word instrument used, it only means a non-testamental instrument and not any testamental instruments. So if we read this definition, we will find that non-testamental instrument means an instrument which operates immovable property used in transfer of property between two or more living persons. For example, gift deed. For example, um, transfer deed, etc. Moving on to the next slide, we have the word attested in relation to the instrument. It means and shall be deemed always to have meant attested by two or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument, or has seen some other person sign the instrument in the presence and by the direction of the executant, or has received from the executant a personal acknowledgement of his signature or mark, or of the signature of some other person, and each of whom has signed the instrument in the presence of executant. But it shall not be necessary as more than one of such witnesses shall be present at the same time, or no particular form of attestation shall be necessary. If we read this, we will find that there are two witnesses which is required, minimum two witnesses which is required to execute a witness, execute a document, and that if if the witness sign if the witness sign the instrument in the presence of the executant, and it is then it will be said to be attested. There are two very important things about the attestation which have been reiterated in the ML Abdul Zawar Sahib versus HB Venkataya Sastri and Sons, which first says that it should be amino attestandi, that is two or more witnesses have seen the executant sign the instrument or has received from him the personal acknowledgement of the signature. That is, the executant has signed the instrument in the presence in the presence of the witnesses, or they have told the witnesses that they have signed the instrument. They have signed the instrument. The acknowledgement should be very personal, because if it comes from the any third person, it won't be it will not amount to attestation. And second thing, that the when the witness is attesting the instrument, the presence of the executant is necessary, so that it confirms the attestation process. Also, uh, also uh, also the witness can attest the instrument if any other person has signed the instrument on the direction of the executant. Means, if somebody has the power of attorney in behalf of the executant and he has signed the document, then also witness can affirm the same. That will also amount to attestation of the instrument. And the court should be satisfied in every case that the um, that the uh, satisfied that the instrument written is amino attestant die. Moving on to the next slide, we have the word registered. Registered means registered in any part of the territory to which this act stands under the law for the timing in a force regulating the registration of document. Means the said uh, document or anything is registered in the territory where this act extends for the timing in force regulating the registration of document. So here we can see that if the document is registered anywhere in this anywhere in the country where this act is applicable, then it will amount to registration. Moving on to the next definition, this says attached to the earth means rooted to the earth as the case of trees and shrubs. In case of trees, it will amount to the things that is attached to the earth. And in second thing is embedded in the earth as the case of walls or buildings. Means the walls and buildings of walls and building, it also amounts to attached because they are permanently affixed to the earth or soil, whatever you can say. And third is or attached to what is so embedded for the permanent beneficial enjoyment that is that to which it is attached. Third thing is if we attach some movable property permanently for the beneficial enjoyment, then it will also amount to immovable property. Example are doors, windows, which are movable property, but once they are affixed, they would become immovable property, and it will amount to the attached to the earth. Moving on to the next slide, we have notice. Uh, it reads that a person is said to have notice of the fact when he actually knows the fact, or when by but for willful abstention from an inquiry or such which he ought to have made, or gross negligence he would have known it. So basically, notice is that means a person knows about the fact and circumstances of the thing or the case or whatever the property they are buying or selling, whatever be the property, and also it amounts to notice when there is willful abstention, that is the person is not going to the property where he is supposed to buy that property, and this amounts to gross negligence. If and that means if he has gone to that property to see whatever property he is buying or selling, then he would have known about it. So this also amounts to notice. If the person is willfully abstaining from his duty, then it will also amount to the notice. So this actually this provisions talks about two types of notice, that is actual notice, which has the person actually knows the fact, and the second thing is constructive notice. It means uh, the person should have known it, but just because he will fully choose to abstain from it, and hence he doesn't know it. So for the constructive notice, in the case of Ahmedabad Municipal Corporation of City of Ahmedabad versus Haji Abdul Ghafoor Haji Hussain Bhai, Supreme Court held that the circumstances which are deemed fictional impute notice to a party are based on a willful abstention to inquire or such which a person ought to make, or its gross negligence. Notice is commonly known as constructive notice. It means the Honorable Supreme Court has held that if someone should know about the fact of the case, or someone should know about the immovable property, but he just willfully abstain from inquiring about the same, or just because of his gross negligence he is not able to get the right character of that property, this notice is amount to constructive notice. Moving on to the next slide, we have examples of constructive notices. These are explanations of the notice. In explanation 1, we know that if some movable property is required by law to be registered, then if once the property has been transferred to a registered document, this means this amounts to a notice to the whole world, and this amounts to also a constructive notice, so that in future if someone is going to buy the property, they should know actually on whose name the property is registered, and to whom it will be transferred, or from whom they are buying it. So if a property is registered somewhere, it amounts to a constructive notice. Moving on to the next, moving on to the second example, we have explanation number 2, which says that any person acquiring any movable property or any share or interest in any such property shall be deemed to have notice of the title, if any, of any person who is from the time being in actual possession thereof. It suggests that if any person is acquiring any movable property, then he should know about who is having the title of the property, or who is in the actual possession thereof. Means if someone is buying a flat from someone, suppose X is buying a flat from Y, so X should go to the flat and he should see whether the flat is vacant, or the flat is acquired by some renter. If there is, and if there is a rent, if someone is on rent, then he should actually accept him as a renter, or he should ask why to vacate the said premises before buying it. Moving on to his explanation number 3, a person shall be deemed to have had a notice of any fact if his agent acquires notice thereof, still acting on behalf of the course of business of which the fact is material. To which that fact is material means if someone agent has having a notice, then it will also amount to constructive notice, because the person is acting through his agent, and if his agent acquires a notice of something, then it will also amount to a notice, provided there is a proviso also, if a agent fraudulently conceals the fact, then the principal should not be charged with notice thereof, and against any person who was a party or otherwise cognizant of the fraud. Means if the agent acts fraudulently, then principal shall not be charged, and charged with a notice against any party. Means if the party is innocent, or whether the party is also knowing the fraud thereof, then also the principal will not be charged. Moving on to the next slide, we have section 4, which says enactments relating to contracts to be taken as a part of contractor and supplemental to the registration. This suggests that this act is not exhaustive, the TP is not exhaustive, as we have seen earlier. Some parts, some of the words which are used in this act, which are already the part of Indian Contract Act, shall be taken from the Indian Contract Act, and also this act will supplement the Indian Registration Act. So, if we read the slide, we see that the para first is the chapters and section of this act which relates to contracts shall be taken as part of Indian Contract Act 1872. This clearly suggests that if something relates to the contract, it should be taken as a part of Indian Contract Act. And second para and section 54, paragraphs 2 and 3, 59, 107 and 123 shall be read as supplemental to the Indian Registration Act 1908. Means this act will supplement the Indian Registration Act, and hence this act is not exhaustive. And of course, this section 4 totally affirms the status of the non-exhaustive nature of this act. Moving on to the next slide, section 5, it defines transfer of property. If we read section 5, in the following sections, transfer of property means an act by which a living person conveys property in present or in future to one or more living person, or to himself or one or more other living person, and to transfer property is to perform such act. In this section, living person includes a company or association or body of individual, whether incorporated or not, but nothing else herein contained shall affect any law for the time being in force relating to transfer of property, or to or to by companies, association, or body of individuals. So if we look at this section, they have many small words which need to be explained to understand this section. Uh, First is the word enact. The second is by living persons. Third is conveys. Fourth in present or in future. Fifth is one or more other living persons. Second is or to himself. Um, Seventh is or to himself and one or more living persons and transfer property in is to perform such act. So first we will look at an act. An act means we have to do something. Like we have to sign a deed, we have to sign something to just we need to do an activity so that the property can be transferred from one living person to another, because this transfer of property only works when the transfer happens between a living person and another living person, and not between a dead and a living person. So it's only work when a non-testamentary instrument is signed by a person, and hence that is an act. Moving on, uh, moving on to the second thing, that is transfer between living and living. We have talked a lot about it, that the act only deals with the non-testamentary document, that is a transfer between living and living persons, and this transfer is also known as inter vivos. Third thing is conveys. Conveys means any act of the transferor by which certain new titles or interests are created in favor of the transferee, and extinguishment of prior certain titles of interest of the transferor. After the transfer of property, the transferee gets the certain rights or interest which is transferred by the transferor. Conveys means means a person has a title or interest, and he creates in a favor of transferee. That is the right before the transfer of that property is now being now distinguished for the transferor, and then new set of rights and interests is created in favor of the transferee. So in this in the case of Narandas Karson Das versus A.S.A. Khamtam and another, Supreme Court, the Honorable Supreme Court observed that the word conveys in Section 5 of the Transfer of Property Act is used in a wider sense of conveying ownership. Means basically it's transfer the it's a transfer of ownership to one person to another, and except in some cases like uh, lease, the ownership is not transferred, but all the other rights or the interest is created in favor of the transferee. Now moving to the fourth thing, in present or in future. These words indicate that the transfer of property may be done promptly or sometime in future as the agreement between the parties. If the agreement suggests that the transfer will be done right from the moment, it is done right from that moment only. And if it suggests that it will happen in future, then it can happen in future. Whatever the agreement between the parties, there is no bar as such that if an agreement is done between the parties, the property shall have to be transferred from that moment only. It can be transferred in future. It can be transferred in present also. Moving on to the fifth thing, that is himself. That a person can transfer the property to himself also, but in a different capacity. It just means if a person becomes a director of a company or trustee of a trust, then he can transfer his property to the person, to himself, as a director of the company or the trustee of that trust, but but he cannot transfer it to himself in the same capacity. The capacity have to be different. Like the person is a different person when he is holding the property, and the person is a different person when to which he is transferring the property. Again, moving on to the sixth thing, that is himself and one or more living person. Again, the word himself has been used. You will find that in some barracks the second himself has not been used. But if we I have downloaded it from in the indiacode.in, so it suggests that word himself is written. So I think this is the correct mm, correct Barak. So in this case, the himself and one or more living person suggests that a person can transfer the property to himself and other living person, but again the himself should be in different capacity. That is, the person becomes the director of a company with two or three other person. Now if he wants to transfer the property to the director, then he can always transfer that property. And that's why the word himself and one or more living person has been used. So the again here in this himself also the capacity should be different. Moving on to the next section, we have section 6 that suggests what may be transferred. This is the most important thing, what may be transferred. Like property of any kind may be transferred except as otherwise provided by this act or by any other law for the time being in force. The chance of an heir apparent succeeding to an estate, the chance of relation obtaining a legacy of a death of a kinsman or any other mere possibility in like nature cannot be transferred. This clause is based on a maxim spec successness, means the speculation that a person will acquire an interest or right in the property in future, it shall not be transferred at all, because you never know that you will inherit that property or not. Means you can't just speculate that the property will be mine in future. Just if we go by the book, like a father, property is generally transferred to the son when the father dies. But in but this is a mere speculation that the property will be succeeded by his heir only. Because if the father writes a will to someone else, then the property will be transferred to that another person. So this speculation that the property will be transferred to his heir only uh, gets a hit here. So this cannot be done. Like if a son is speculating that the property will be come to him when once his father dies, he cannot transfer that property at the present, because that is the property which he will get in future. So there is also a thing that one cannot transfer a better title what he have at the present. Like if I don't own something, I can't transfer it to someone else. Hence, the transfer of property, which is a future property, is barred by this act at all. So one cannot transfer the property which is not his, and he is just merely speculating it. So moving on to the second clause, that is clause B, a mere right of re-entry for breach of condition subsequent cannot be transferred to anyone except to the owner of property affected thereby. That is, if a condition subsequent is breached, that condition subsequent is breached, it doesn't create a right to re-entry to any third person, but it creates a right to a re-entry of the owner. This is just done. This is a provision just for a lease thing, that once generally in lease we have a provision that uh, if the if the lessee is found doing some illegal work, then the lessor has a right to have a re-entry and have possession of the property again, and by giving notice or whatever, that is based on the contract whatever they have between them. But that re-entry shall not be transferred to any third person. It shall only remain intact with the owner only. So in this case the owner cannot transfer that re-entry to any third person. It have to the owner have to keep it with himself only. So moving on to the third thing, that clause C, that an easement cannot be transferred apart from the dominant heritage. That the easementary right is a very important right. So if we look at this picture, we can understand that this is a property which has a right to way from these properties. Now, the property which has a right to way is known as dominant, it is known as dominant heritage, and the property which serves this property is known as servient heritage. So this right to way cannot be cannot be sold by this person because this right to way to his property is inherent right of this dominant heritage, and it cannot be sold by this servient heritage. It can be only be sold by the permission of this, or it can or it cannot be transferred at all. So if this is mental right belongs to this dominant heritage, and this is totally this is totally inherent to this dominant heritage, and hence it cannot be transferred at all. So moving on to clause D, we have an interest in property restricted in its enjoyment to the owner personally cannot be transferred by him. Means if some property is restricted to the enjoyment only of the owner personally, it cannot be transferred. For example, we have Khalcha Pandan in the Mohammedan law, which is known as Vital Box expenses, which is exclusively used by the ladies only. So it cannot be transferred, and we have also something called Istridhan in the Hindu law. Again, moving on to the next clause, that is DD. A future right of future maintenance is whatsoever manner arising, secured or determined, cannot be transferred. That is, if there is a right of future maintenance, it cannot be transferred. The maintenance has to be there, and then it can be transferred. But if it is a future maintenance, it cannot be transferred. Again, a mere right to sue cannot be transferred. That is a mere right to sue of is a mere right to sue is of a nature of unliquidated damages. So if the amount is not ascertained, it cannot be transferred. If the amount is ascertained, it can be transferred. Like it can be transferred as a form of actionable claim, which we will read in the coming videos. But if it is not ascertained, just means if somebody has caused negligence to someone, then just like if X wants to sue Y for a negligence, X cannot transfer this right because the amount which will he will get as an unliquidated damage, it is not ascertained, and hence it cannot transfer the same. Again, a public office cannot be transferred, nor can the salary of public officer. Like I am holding a public office, it cannot be transferred. It cannot be transferred to anyone, my friend, my family members. It cannot be transferred to anyone, and nor can the salary of this public office can be transferred to anyone. Again, if we move on to clause G, it also suggests that the stipend allowed to military, naval, air forces, and civil pensioners of the government and political pensions cannot be transferred. Again, the same thing. This these are all government things. The stipends of the military, naval, air force, it will be transferred to only the person who is holding that post, and it cannot be transferred to someone from his family or anybody else. Uh, Moving to the clause G, we have no transfer can be made in so far as it opposed to the nature of the interest. And nature of the interest affected thereby means that if nature is affected, that the community is affected, as the society is affected at large, it cannot be transferred. Like something is some transfer of something is totally bad. That includes water, air, light, space. These things are like impossible to transfer, but it can be transferred. But sorry, but it cannot and it cannot be transferred at all. Moving on to the next slide. Moving on to the subclause 2 of clause G, we have an unlawful object or consideration within the meaning of section 23 of the Indian Contract cannot be transferred. This is already we have read in the Indian Contract Act that if an agreement made for an unlawful object or consideration, it will be void ab initio. This is the this subclause is basically the reiteration of the same fact that if the object is unlawful or consideration is unlawful, it cannot be the transfer is not valid. Uh, Moving on to the subclause 3 of clause G, to a person legally disqualified to be a transferee. Means if a person is legally disqualified, means the person is competent, but it has been, but he has been legally disqualified uh, by the law for the timing in the force. That is, the law has specifically barred someone to become a transferee. So, for example, as we are a citizen of India, we can buy land anywhere else in India, but in certain areas we cannot buy land because it has been restricted by the law for the time being in force. Hence, where we cannot buy land, we are legally disqualified to buy that land. So, if generally if we have read the constitution, we have schedule 6, which says that there is certain area which is protected by the Indian constitution has. So in that area we cannot buy land, and hence we are legally disqualified to buy land there because of the law. The law wants to protect that area from the encroachment of other people, because the tribal, they want to protect the culture and the culture of the tribal community. So the law specifically bars someone to buy land, but even though they are competent to buy land anywhere else in India. So next thing is moving on to the clause I. We have nothing in it suggests that nothing in this section shall be deemed to authorize a tenant having an untransferable right of occupancy, the farmer of an estate in respect of which default has been made in paying revenue, or the lessee of an estate under the management of court of wards to assign his interest as such tenant, farmer, or lessee. Basically, there are many type of lands. Uh, one we have a ownership, total ownership of a land. Second is the government gives someone tenancy of the specific land. So if the government is giving tenancy of that land, it only uh, it only gives you the occupancy right. It doesn't give you the right to transfer that land to someone else. Hence, the occupancy, the tenancy right is untransferable in nature, and hence you cannot transfer that right to someone else. Hence, this clause suggests that we cannot transfer a mere right to tenancy. That is, it only gives us the right to occupancy, and hence we cannot transfer that. Again, if there is a default in paying of revenue, then that land cannot be transferred. If there is a revenue, there is a default in revenue, then the land cannot be transferred, because once there is a default in revenue, the first case, the means the first right to buy on the land belongs to the government, and hence if there is a default in revenue, then it cannot be transferred. So moving on to the next slide, we have section 7, which says that person competent to transfer. Section 7 gives us the provision as to who can transfer the property. So if we read this provision, we have every person competent to contract and entitled to transferable property or authorized to dispose of transferable property not his own is competent to transfer such property either wholly or in part or either absolutely or conditionally in the circumstances to the extent in the manner allowed and prescribed by any law for the time being in force. So every person competent to contract. This is the first thing we have to see. So every person competent to contract is given under Section 11 of the Indian Contract Act, which has three rules for the competency of a person to contract. That is, first is the age of majority, second is who is of sound mind, and second is who is not disqualified, and third is who is not disqualified from contracting by any law to which he is subject. So there are three things which is necessary for a person to contract. That is, first he should be of more than 18 years old, and second he is of sound mind, and third he is not disqualified for contracting by any law. That is, he is not disqualified by disqualified. He is not a disqualified person by law. as we have seen in the earlier slides. So this is what it means by every person competent to contract. Next is entitled to transfer the property. Means the person should be entitled to transfer that property. The person should be having the rights and interest in that property at the present time, not in a future. So if the person is having the property, having the title at the present time, then only he can transfer. As we have already seen in the aspect, successor cannot transfer it. There's also a maxim that is known as nemo dat quod non habet. That means no person can transfer a better title than he himself has. Means if a person is not having that, not having the title, he cannot transfer the property. So if the person is not entitled to transfer that property, he cannot transfer the property in any case. Third is or authorized to dispose of transferable property not his own. This line basically talks about the power of attorney. That if a person is given power of attorney, even if the property he doesn't own the property, he can transfer the property in certain cases, like for lease, um, uh, for for lease or for certain purposes, because Supreme Court in a landmark case in 2007 has disallowed the practice to transfer the property by a power of attorney. So, if a person is authorized to dispose the transferable property, then he can transfer the property. Moving on to the next slide, we have section 8, that is operation of transfer. It suggests that unless a different intention is expressed or necessarily implied, a transfer of property passes forthwith to the transferee. All the interest which the transferor is then capable of passing the property and in the legal incident thereof. This means if a operation of transfer happens, if a transfer happens, then everything which is with the property, that means the transferor transfers all his right, all his interests, which he is capable of passing in the property to that transferee. And also, if there is some legal incident there too, then also that legal incident also get transferred thereof. Means if some charge or some encumbrance is there on the property, then also that charge or encumbrance also get transferred to the transferee. Although it is a it is a it is a requirement of the law that the property should be free of charge or encumbrance. But even though if the person is willing to take the property, knowing that the property is on charge or having some encumbrance on it, then also that legal incident, then in this circumstance, the legal incident can be transferred thereof. As said by the Honorable Supreme Court in the case of Jugal Kishore Saraf versus Raw Cotton Limited. It is the section 8 that act of transfer of property passes to the transferee all the interest which the transferor is then capable of passing in the property and in legal incident therefore, and if the property transfer is a debt or actionable claim, also the security is there. Means if the property is a debt or actionable claim, then if there is some security which is incidental to debt or actionable claim, then it also passes through that transfer. Now, if we read another paragraphs of this section 8, such incidents include where the property is land, the easement annexed thereto, the rent and profit thereof accruing after the transfer, and all things attached to that. Means if the property is a land, then the easement rights, because it is an inherent right, it get transferred. The rent and profit thereof means if there is a rent or any profit which is accruing after the transfer, then also that rent or profit should be transferred to the person. And third is all things attached to that. Means if there is a tree, if there is a house on that land, then also that get transferred to that person to whom the property is transferred. Moving on to the next para, and where the property is machinery attached to the mobile parts thereof. So if there is some masonry thing attached to that, for example, a generator is attached to that. So the movable part means any remote or anything which you use to start the generator will be transferred thereof to the person who is the transferee. And where the property is a house, the easement annexed thereto, the easement annexed thereto, the rent thereof accruing after the transfer, the lock, keys, bars, doors, windows, and other things provided for the permanent use. Means if it is a house, then again the rent and after the transfer, lock, keys, bars, doors, windows, everything which is for the permanent use, other thing provided for the permanent use shall be transferred. And where the property is a debt or other actionable claim, the security therefore, as reiterated by the Supreme Court in the Honorable Supreme Court in the case of Jugal Kishore Saraf versus Raw Cotton, means that if the property is a debt, if the transfer is of debt or actionable claim, then if there is some security, the some security means somebody has given a papers of land for the debt, then the paper should be also be transferred to the person to whom the debt is transferred. And where the property is money and other property yielding income, the interest after the transfer takes place. Means if the property is money or the property is yielding some income, then the interest shall be transferred to the person after the transfer takes effect. Means if the transfer has happened, then if the property is yielding some income, then the interest also should be paid after the transfer. So now in the next slide we come to section 9 that talks about oral transfer. A transfer of property may be made without writing in every case in which writing is not expressly required by law. So a person can transfer the property orally also. It can transfer by writing, it can transfer it by writing, it can transfer it by oral, by oral contract. So if it is, but oral contract is only permitted when it is not expressly required by law to be in writing. Means if for example if there is a lease of 11 months, it need not be registered, so it is not required by law to be in writing, so there can be an oral agreement regarding the same. If we read the para 2 of sale how made under section 54 of TPA, we'll find that a tangible immovable property of less than Rs 100, then such transfer may be made either by registered instrument or by the delivery of property. Means if the property is having the value of 100 rupees, then it can be made by either registered deed or by delivery the property by delivering the property. So if the property is being delivered and it is of less than Rs 100, then it is the oral transfer and it is permitted under this act also. So oral transfer can also be made. But if the property is more than 100 rupees, then the registration is required. Registration is required, and if the registration is not done, then the property is not transferred. However, if the property is below 100 rupees, then also person can go for registration. But here, oral transfer can also be done. Moving on to the next slide, we have section 10 that suggests condition restraining alienation, where property is transferred subject to a condition or limitation absolutely restraining the transferee or any person claiming under him for parting with or disposing of his interest in the property. The condition or limitation is void, except in the case of lease, where condition is for benefit of lesser or other claiming under him, provided that the property may be transferred out of benefit of a woman not being Hindu, Mohammedan or Buddhist, so that she shall not have power during her marriage to transfer the charge, and same for her beneficial interest therein. So it says that if there is a condition which restrain a person to alienate that property after the transfer, then the transfer is not void, but that condition or limitation is void. So it's very clearly says that if we read this provision, we will find that if the person is transferred a property with a condition or limitation to absolutely restraining the property, the transferee from alienating, absolutely restrain means the restraint, if there is partial restraint, then it is fine, but if that condition or limitation is of absolutely is of a nature that absolutely restrains the transferee from alienating the property, then the condition or limitation is void, except in a case of a lease where condition is for benefit of a lesser one. If in a lease, of course, in a lease we cannot transfer the property. If we transfer the property, then the lesser will will be at loss. So we cannot transfer the property in a lease. However, and also in if a property is transferred to a woman, if she is not Hindu, Mohammedan, or Buddhist, for her beneficial interest, for her enjoyment, she cannot sell it during the marriage. So this again, this she cannot sell it during her marriage. So this is not a condition, this is exception, which has been made for section 10. So condition which totally alienate, matlab totally restrains the person from alienating, that will be that condition will be void. However, the property, the transfer will remain valid throughout. So in the case of Zoroastrian Cooperative Housing Society Limited and another versus District Registrar Cooperative Society Urban and others, the Honorable Supreme Court observed that the Section 10 of the Transfer of Property Act relieves a transferee of immovable property from absolute restraint placed on his right to deal with the property in the capacity as the owner thereof. As per Section 10, a condition restraining alienation would be void. The section applies to the case where property is transferred subject to the condition or limitation absolutely restraining. Again, the Supreme Court is emphasizing on the word that absolutely restraining the transferee from parting away with the interest in the property will be a void condition, and hence it will not be applicable. For making such condition invalid, the restraint must be absolute restraint. Means if the condition is, if you want to make that condition invalid, the restraint should be absolute. Absolute means there the person, the restraint on the person put on the person is absolute, and it must be a restraint imposed while the property is being transferred to the transferee. Means the restraint imposed on the property is at the time of transfer and not at the time of transfer and not before. So it must be restraint imposed while property is being transferred to the transferee. Means when the property is being transferred to the transferee, the restraint has been imposed, and the restraint should be absolute. The partial restraint is allowed. Just like if you are buying a land and somewhere, and there is a condition that you should sell it to a specific community, you can sell only to this specific community, then it is a partial restraint, and this is allowed in the law. But if it says that I am transferring this property but you cannot sell it, so this is absolute restraint, and this is not allowed in the law. This what we are talking about, partial restraint, in the case as the Honorable Supreme Court held that in the case of Gumana Sethi and others versus Nagave Niyama, held that the Honorable Supreme Court held that the partial restraints are valid if imposed in a family settlement, partition, or compromise or dispute claims. Moreover, lease is an exception to this rule. Also, again, lease is an exception because if we transfer the property in a lease, then the lessor is on a losing side. Also, any condition or limitation restraining allegation put by any traditional for the benefit of woman during her marriage will be legal. Means if there is a limitation which has been put for the benefit of a woman not being Hindu, Mohammedan, or Buddhist, then it will be a legal then it will be a legal restraint, and a partial restraint is also allowed in the law. Moving on to the next slide, we have section 11, restriction repugnant to the interest created, where it is basically the extension of the section 10. It suggests that if there is some restriction put on the property, that you should enjoy it in a certain way or you should enjoy it in that manner, so it will be a void condition again, and the person who has received the property, it will be for him it will like he has received the property without any such direction. So if we read this provision, it goes like where on a transfer of a property, an interest therein is created absolutely in favor of any person, but the term of a transfer directs that such interest shall be applied or enjoyed by him in a particular manner. He shall be entitled to receive and dispose such interest as if there was no such direction. So here again, if there is a interest created absolutely in favor of someone, like the person, the interest has been created in favor of a person. Now, if there is a direction that you should use this property in this way only, or you should use this property in this particular manner only, then he has received that property without such direction. The law directs that he has received such property without any such direction, and and the and the condition that you should enjoy it in a particular manner is a void condition. Now there is an exception to this rule, which says suggests that where any such direction has been made in respect to one piece of immovable property for the purpose of securing the beneficial enjoyment of another piece of such property, nothing in this section shall be deemed to affect any right which the transferor may have to enforce such direction, or any remedy which he may have to have in respect of a breach thereof. Means if if there is a direction which is made in respect to one piece of movable property for the purpose of securing the beneficial enjoyment of another piece, means if we take the example of easementary right, so this easementary right is created for the beneficial enjoyment of another piece of such property, and another piece of property. So this so that if there is a restriction that you should not use, you should have to give this easementary right to the another person, then this condition is a valid, that you should not use that way, or you should not block that way. So this is a very valid interest for of the another property. So in this case, this direction will become a valid direction, and hence the person who is enjoying the who get the property, that is the person who is the transferee, will have to follow this direction, and if it doesn't follow this direction, then it will be a void, then he is going against the law basically. So in this video we have read from section 1 to 11, and we will continue this in another videos, with another video. With this act we will read right of unborn child, we will read sale, we will read gift, we will read an actionable claim, etc. in the coming videos. So thank you for listening, and I hope you will understand and to comment for any suggestion whatever you want, and thank you very much once again. Bye.